Straight ahead on Law and Crime Daily. Convicted murderer Robert Durst is sentenced to prison time.
You got nothing else to do something right once and finally.
How long the real estate heir will spend in prison. And the death of Ahmaud Arbery.
I need to get this blood off my hands.
We bring you up to speed from the first gunshot to next week's opening day of trial. Plus, from the White House to the Big House, why former Trump advisor Steve Bannon could spend time behind bars. And later,
how do you wish to plead?
Guilty.
The accused Parkland school shooter enters a guilty plea. We look ahead to Nicholas Cruz's penalty phase. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer along with Terry Austin. Nearly 21 years after Susan Berman was found shot to death in her Beverly Hills home, her best friend Robert Durst is sentenced to life without parole for her murder. Law and Crime's Angela Levy is here with what happened at sentencing and why Durst's legal troubles may not be over.
Yeah, Brian, that sentence of life in prison without the possibility of parole, really, it was a foregone conclusion. No surprise there, since Robert Durst was found guilty of first-degree murder with special circumstances. Now, Durst did not speak during that sentencing hearing in Los Angeles. You may recall he did a lot of talking when he was on the stand. He was up there for nearly 14 days, and he admitted to lying during his testimony, but insisted he did not kill Susan Berman. Prosecutors argued that Durst killed Berman to silence her about the disappearance of his first wife, Kathy. She disappeared in 1982, and her body has never been found. Susan Berman's loved ones spoke to the judge at sentencing.
I was robbed, and my beautiful son was robbed of an absolutely extraordinary, unforgettable, brilliant person whose life was savagely taken from her at 55 when she had many years ahead.
All I can attempt to tell you is what life has been since my mother's murder. It has been a daily, soul-consuming and crushing experience. Since my mother's murder, there has not been one day that I've not lived that this has not been at the center of every thought, feeling, choice, or breath I take. I have not had one day off in almost 21 years from the absolute destruction, grief, or pain that this has caused me.
Now, News 12 out of New York has been reporting that the Westchester County District Attorney's Office will soon start presenting evidence to a grand jury against Robert Durst in the death and disappearance of Kathy Durst. And I've reached out to the Westchester County DA's office to try to confirm that information. So far, I have not heard back from the spokesperson there. Meanwhile, Robert Durst's attorney, Dick DeGuerin, tells Law and Crime that he's only heard rumblings like we have about this grand jury, but he said if that grand jury is fair, that Robert Durst will not be indicted. Brian.
Thanks, Anjanette. Joining us today is defense attorney Bruce Barquette and Terry Austin. Bruce, the defense made 15 last-ditch efforts by filing motions after the verdict, but ultimately Durst was sentenced. Is this case final, or do you see any appeals?
Well, there certainly will be an appeal. He's got a life without parole sentence, so that undoubtedly he'll take an appeal. It sounds like Mr. Durst is going to be a full employment opportunity for lawyers into the future in New York, in California, and perhaps in Louisiana as well. This was a case, if you recall, where they used a full-length video to present to the jury. And I say video, I mean made-for-television movie, because somehow it provided some adaptive omission to the prosecutor. I thought that was an outrageous abuse of discretion. I think that that alone may end up causing a reversal of this conviction.
Absolutely. Now, Terry, we saw this sentence coming, but what did you make of the judge's final words to Durst?
I thought Judge Wyndham was really fairly straightforward during the sentencing. He patiently listened to those motions, but I think at the end, he ultimately said that he got to know Susan Berman and he felt bad about that loss. And then ultimately, he did sentence him to life in prison without the possibility of parole.
And Jeanette, did any of the jurors attend the sentencing?
Yeah, it was really interesting, Brian. Jordan Chacon, one of our producers here at Law and Crime, she said she recognized at least 5 jurors, and she said that it appeared they had family members with them as well. And she said that those jurors were really kind of hanging on every word as the family members of Susan Berman spoke and really as the judge spoke. So it was interesting. They obviously were interested to see what would happen at the sentencing. And you can, tell obviously from them attending that they are invested in this case emotionally. It went on for 4 or 5 months, the trial did.
Yeah, thank you for that insight. And Jana, of course, thank you, Jordan, for being there to give us that reporting. And on to other top legal news, former Minnesota police officer Kim Potter may claim the shooting death of Daunte Wright was a, quote, innocent accident. In April, Potter shot and killed a 20-year-old at a traffic stop. Potter, a 26-year-old veteran of the police force, said she was going to use a taser, but instead shot Wright with a gun. In a court filing on Thursday, Potter said she may use one of the following defenses in the death: innocent accident or innocent mistake, her perceived use of the taser was reasonable, or lack of causation. Potter is facing manslaughter charges in Wright's death. Her trial is set to begin on November 30th. And a Florida man is charged in the death of his girlfriend after their 2-year-old son shot and killed her as she made a Zoom call for work. 21-year-old Shamaya Lynn died in August after her son found an unsecured handgun and pulled the trigger. Officials say the gun belonged to 22-year-old Viandre Avery, Lynn's boyfriend, and the toddler's father. Court documents show Avery kept the weapon in a backpack decorated with animated characters from a children's show. At the time of her death, Lynn was on a Zoom call with coworkers. One of them called 911 after hearing shooting, saying she, quote, heard a loud noise and the child in the background began to cry. Avery was charged with 2 counts this week: failure to securely store a firearm and manslaughter. Still ahead on Law and Crime Daily, the accused Parkland school shooter expected to enter a guilty plea for the 2018 school massacre, not before his guilty plea in a jail battery case. But first, the timeline of events leading up to Ahmaud Arbery's death, what to expect in the coming trial. It was the video that shocked the nation. An unarmed black jogger, 25-year-old Ahmaud Arbery, gunned down in broad daylight.
We are going to make sure that we find justice in this case.
The 3 men charged will now stand trial.
I told him stop till he hit me. I had nothing to do. There's nothing else I can do.
You're a passerby coming through?
Nah, not necessarily.
That's my son that shot him. I was at the back of the truck.
Starting October 18th, watch live Gavel to Gavel coverage on the Law and Crime Network. Welcome back to Law and Crime Daily. Nearly 2 years in the making. A trial will finally begin with jury selection on Monday for the death of Ahmaud Arbery. Ahead of jury selection, Law and Crime Daily's Sierra Gillespie breaks down the timeline of the case.
Brian, in the nearly 2 years since the death of Ahmaud Arbery, the case has taken many twists and turns, complete with what some call delayed arrests, graphic viral video, and recused district attorneys. As all eyes move to Georgia for next week's jury selection, we take a look back at where it all began.
His name was Ahmaud Arbery. He was 25 years of age. He was a resident here in Brunswick, Georgia. He was involved in athletics, liked to play games outside. He liked to run, liked to play video games.
For Ahmaud Arbery, February 23, 2020 was just another day, but only 2 miles from his Brunswick, Georgia home. The gunshots heard round the nation, paired with a chilling cell phone video that shows a once physically fit 25-year-old suddenly keeling over in the middle of the road.
I don't believe it was self-defense by Mr. McMichael. I believe it was self-defense by Mr. Arbery. I believe Mr. Arbery was being pursued, and he ran until he couldn't run anymore, and it was turning back to a man with a shotgun or fight with his bare hands against the man with the shotgun, and he chose to fight.
Video taken from William Roddy Bryan shows father and son duo Greg and Travis McMichael tailing Arbery with a pickup truck, eventually firing shots that would be fatal. The McMichaels would tell police they chased Arbery down because they believed he was responsible for break-ins in their neighborhood.
From the interior video of the house, you see him just wandering around, again, not taking anything.
The father and son claimed when they approached Arbery, he attacked Travis McMichael, who fired his weapon in self-defense.
That's my son that shot him. I was at the back of the truck. I need to get this blood off my hands.
After that, Travis McMichael stands over Arbery's body as he dies, making racial slurs.
Mr. Bryan said that after the shooting took place, before police arrival, while Mr. Arbery was on the ground, that he heard Travis McMichael make the statement.
By late February 2020, the Brunswick Area District Attorney Jackie Johnson would recuse herself from the case, saying Gregory McMichael was an investigator in her office for more than 30 years before his 2019 retirement. By April, a second prosecutor would recuse himself after defending the actions of the McMichaels and Bryan. 1 month later, the cell phone video of Arbery's shooting circulates online, creating national outrage. Days later, Gregory and Travis McMichael are arrested.
Jackie, this is Greg. Could you call me as soon as you possibly can? My friend and I have been involved in a shooting, and I need some advice right away.
2 weeks later, Bryan is also arrested and charged with murder and criminal attempt to commit false imprisonment.
William Bryan conspired with 2 other men to kill my youngest son.
Days later, the Department of Justice begins an investigation into Arbery's death, as well as 2 DAs who recused themselves from the case. By November, Jackie Johnson is voted out of office. Days later, a judge denies bond for the McMichaels. In April 2021, a federal grand jury indicts the McMichaels and Bryan with hate crimes and attempted kidnapping. A month later, Arbery's accused killers plead not guilty to those federal hate crimes. In August 2021, a judge orders Arbery's past run-ins with the law cannot be used by the defense. 3 days later, former DA Johnson is indicted on charges related to the Arbery death investigation. At the start of October 2021, a judge rules Arbery's past mental health records cannot be used as evidence by the defense team when the case goes to trial. The federal trial of Gregory and Travis McMichael and William Roddy Bryan is set for February 7, 2022. The state trial in the death of Ahmaud Arbery is set to begin on Monday. Stay tuned to Law&Crime Network for complete gavel-to-gavel coverage of the case and a day-by-day breakdown. For Law&Crime Daily, I'm Sierra Gillespie.
Thanks, Sierra. Let's bring back criminal defense attorney Bruce Barquette and Terry Austin to break down the 2 defenses in this trial. Terry, the citizen's arrest defense. How do you take the false imprisonment, and the felony murder charge and fight this in this type of case? And will it work?
Well, the defendants are going to try to argue that this was a reasonable detention. Under the prior citizen's arrest law, you could argue that you could detain someone if you just were in the presence of that crime or you had knowledge about that crime. Governor Kemp actually tried to overhaul it so it wasn't a vigilante type law. And he did overhaul it, but still businesses and individuals, homeowners, can still say that this was a reasonable detention to protect their properties. So the real question here, Brian, is whether or not this was a reasonable detention under the new law.
Absolutely. You know, Bruce, the McMichaels have claimed that this was self-defense, that Travis was protecting himself when Arbery fought him for his gun. Does that argument mean not guilty here?
That seems to be, no, it shouldn't mean not guilty. It's the only thing they can argue. There is a portion of the video where you can see Arbery fighting with the individual with a gun. But what we know is that before that happened, he was chased down by these individuals and confronted. So he had a choice to either continue to run away from a pickup truck or to fight the person with the gun, and he chose the latter and got shot to death. Arbery was the one who was trying to defend himself. Look, the defense has a tough job. They have to say something, so they'll make that argument, but I do not think it'll be successful.
All right, we'll see how it plays out. Those being the 2 main defenses: a citizen's arrest, that they perceived or thought that Arbery is committing a felony in their presence, or self-defense. That's what the defense is going to present in this case. And like Sierra said, make sure to check the Law&Crime Network for gavel-to-gavel coverage as that case begins next week. Coming up on Law&Crime Daily, Nicholas Cruz will likely plead guilty to the Parkland school shooting. But first, he enters a guilty plea on separate charges. Plus, the consequences for former Trump advisor Steve Bannon and the role he played in the January 6th Capitol riots. All that and more after the break. Welcome back. Former Trump advisor Steve Bannon could face a hefty fine or time behind bars as a so-called January 6th committee pursues criminal charges. All this is in relation to the Capitol riots that occurred on January 6th. The House Select Committee in charge of investigating the January 6th attacks requested Bannon provide details about conversations he had with former President Donald Trump. They say those conversations happened leading up to the riots. Bannon claims that since Trump signaled he would fight the committee's efforts, he is not required to respond to the subpoena. The Select Committee will vote next week on whether to adopt a contempt report. If passed, it will be brought to the full House. From there, the Washington, D.C. District Attorney would bring the matter before a grand jury. Bannon faces the possibility of a fine or up to a year in prison if he refuses to cooperate with the committee's demands. Back to break down the latest in the January 6th committee investigation is criminal defense attorney Bruce Barquette and co-host Terry Austin. Bruce, subpoenas, contempt of court, break those down for us, especially in the congressional setting, and how does that work out if Bannon doesn't play ball?
Well, first we have to draw a distinction between the two, right? Contempt of court is one thing. People get subpoenaed to go to court. If they don't show up, the judge can issue a material witness order and have them arrested and brought to court and forced to testify, and if they refuse to testify, held in jail until they comply. This is contempt of Congress, which is different. They have to go through a process. A committee has to vote on it. The whole entire House has to vote on it. Nancy Pelosi has to certify it, and then it has to go to the Justice Department. And I guess the Democrats hope that they enforce this referral and actually prosecute the contempt case. So Mr. Bannon is months away from having to face the music, so to speak.
All right, so we'll see how that plays out. Terry, Bannon said he would ignore the subpoena because of an executive privilege. Does that mean Congress can't subpoena him then?
No, not at all. I mean, they've already subpoenaed him. Clearly, they have the right to do that. And the fact that he refused to show up for this deposition, they've already said they're holding him in contempt. So he was scheduled to appear. He failed to appear. And as we just heard, he can absolutely be subject to the DOJ if, in fact, the full House votes, as the committee has already indicated, that this should be something where he is held in contempt of court. I think ultimately this is going to go to the DOJ, and I do think that ultimately Merrick Garland is going to give some sort of view on it as to whether or not Bannon should be held in contempt. There are others who are talking to the House, and so they have been postponed for now.
All right, we'll see how it plays out. As Bruce said, this is a long road, not a short one. So as we get updates, we'll make sure to give you them. When we come back, a guilty plea from the person who pulled the trigger in the Parkland, Florida shooting. The court appearance from Nicholas Cruz, where he pleads guilty to attacking a law enforcement officer. What comes next for the accused Parkland shooter? Welcome back. Guilty on all charges. That's the plea accused Parkland shooter will likely enter for the 2018 school massacre. On Friday, he entered a separate guilty plea for a 2018 jail battery incident. Nicholas Cruz is charged with the murders of 14 students and 3 staff members from the Marjorie Stoneman Douglas school shooting. Cruz, now 23, originally wanted to plead guilty for the crimes in exchange for life in prison without parole. Prosecutors were persistent in pursuing charges, though, in order to secure a death sentence for the accused school shooter. Cruz is now expected to plead guilty for all 17 counts of attempted murder and all 17 counts of premeditated murder from that day. That means he will skip trial and move straight to the penalty phase, where jurors will decide his fate. On Monday, Cruz was set to begin a trial for the 2018 battery charges after prosecutors say he attacked a jail guard. On Friday, Cruz pled guilty to those charges, opting to go straight to the penalty phase.
14129 to count 1 of the information, attempted aggravated battery on a law enforcement officer with a deadly weapon. How do you wish to plead?
I plead guilty.
Count 2, battery on a law enforcement officer. How do you wish to plead?
Guilty.
Count 3, depriving an officer means of protection. How do you wish to plead?
Guilty.
And count 4, attempted use of self-defense weapon against a law enforcement officer. How do you wish to plead, sir?
Guilty.
I accept your plea of guilty. I find that you are alert and intelligent, that you understand the nature of the charges, that you understand the consequences of entering into the plea. I find that you have made an informed decision with the advice of counsel, and that you're knowingly, voluntarily, and intelligently waiving all of the rights that I just went over.
All right, Bruce, I get why this is good for the government. The victims and their families don't have to relive this. But is there an advantage for the defense to admit guilt and move straight to the penalty phase?
This case for the defense has always been about the penalty phase. The only thing that they're trying to do is save this individual's life. They don't want him to be executed. the strategy involved as to whether or not to go through a trial and try to begin to lay the groundwork for your penalty phase defense, or to forego the trial and go right to the penalty phase defense, is a tough call for lawyers facing these kinds of cases. There's obviously no factual dispute about whether or not he killed the individuals. The only question would be whether or not he has some kind of defense along the lines of a mental disease or defect or something like that, that they could begin to explain to the jury why he did this in an effort to save his life. Usually, you go through the penalty or the guilt phase first, almost no matter what, because you give the jury the opportunity to say guilty and to deny you something. Here, they've decided to go straight to the penalty phase. It's a risky strategy, but I'm guessing they may have good reasons for it. We'll see.
All right, we'll see if it plays out. Risky indeed. Terry, what's the penalty phase in a crime this heinous going to look like? And do you think Cruz will avoid the death penalty?
You know, that's a really good question. The death penalty is still on the table, and that is right. Bruce is absolutely right. They are trying to avoid the death penalty for Cruz here. And I think we're going to see multiple witnesses for both aggravating and mitigating circumstances. For the mitigating circumstances, we might just hear about his mental state. For the witnesses who will testify about how they have been impacted. Remember, we had 17 people killed and 17 people injured. So I think we will get a number of witnesses who are going to talk about what this loss meant to them. So I do expect that it will be a very difficult phase of the trial. And I do expect that the government will still try to keep that death penalty right front and center.
All right, we'll see how that plays as it comes up. Thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.